My clients are 25 retired public employees who, at time of retirement, were entitled to receive COLAs. Most of them, I think, either 19 or 20, were receiving COLAs. The rest had vested. By now, I think virtually all of them are in fact receiving COLAs. In Chapter 78 of the laws of 2010, the legislature altered the formula by which COLAs were being made available, so to effectively eliminate them, dooming public employees whatever they were receiving at the time the law went into effect. They were suspended, but for all practical purposes, they've been eliminated. The trial court acknowledged this court's treatment of pensions in general as contract, looked to the constitutional arguments, and that was his holding. He held on specifically on the debt limitation and appropriation clause. He, in fact, said that as far as he was concerned, we seemed to have better the argument on the non-federal rights, on the inclusion of the COLAs and all the contract issues. So his decision was that the COLA was a violation of two constitutional provisions. We submit and we prove the idea that that was a fundamental error. Both the Supreme Court and this court observed as a matter of passing, first of all, that COLAs are uniformly held to be part of pensions. So in 1997, when the referred to pensioners' rights as non-fulfillable and talked about pension benefits programs, it had to have included the COLA because it excluded medical benefits. As far as the, I'm sorry, the error was an understanding, the court's error was an understanding of the nature of pensions. Pensions are nothing more than deferred compensation. They're earned, including COLAs, they're earned and should be paid for in the year in which they are earned. They're not a future obligation in terms of, or rather, not a creation of a future debt. They're a present obligation to be paid in the future. Pensions, and with them the right to COLA, should be paid into a fund with other contributors' deposits, and the aggregate contributions should earn a better return than a single payers. Both sides benefit because the employer can pay less in deferred compensation than he might have to in present compensation because of the historical returns of the funds. The employee benefits because he or she will probably get a better return than he would if he were making a contribution to a sub-IRA that might be underperforming. So otherwise stated, the contribution should be due in the year it's earned. The constitutional provisions about future binding or binding future legislatures should have nothing to do with the present right to a pension. And the pension, inclusive of that, is a COLA. Otherwise, the state could never enter into any multi-year contracts of any sort. We've learned over the last 10 years or so that funds been violated, and that the other two branches of government have used that is other than the judiciary, have used the pension funds as piggy banks to go on funding sprees without any consequences. That doesn't change the legal landscape. They were never intended, pensions and including of that COLAs.
Excuse me, we really need to keep the door closed. Let's get louder here. Okay, go ahead.
They were never intended to be dependent upon the largesse of the legislature and session at the time they would be paid. They were to be funded on an ongoing basis. So, surely in the current environment, there are hundreds of contract cases within the system where the states fail to reserve against collection. And that's what we're really talking about. Talking about paying presently contracted debts, which may be payment for which has not been funded.
Okay, let's assume for the sake of argument that it's a contract. Under constitutional law, that doesn't necessarily mean that you win, does it? It means that there then has to be a hearing or a determination as to whether the state meets the criteria under which it can, under certain circumstances, impair a contract.
Well, in this case, the underlying right has already been, was determined in 1997 to be non-forfeitable.
Okay.
So-
Non-forfeitable means contract, but my question is, under constitutional law, there are certain circumstances in which a state can impair a contract, are there not?
There are certain circumstances under which a state can impair a contract, but the threshold issues have to be met.
Right, and that's the issue that the trial judge didn't address.
He
Didn't get there.
He didn't get there, but we said that we really don't have to for a number of reasons. Because if there's going to be any kind of hearing in a trial court on that issue, the first hurdle that the opponent has to overcome is what I just alluded to. The 1997 rule for non-forfeitability. So,
But isn't this circular? I mean, you're saying, I'm asking you to assume hypothetically,
Okay.
that we agree with you.
Okay.
It's a contract, it's non-forfeitable, but then you get to the issue that the trial judge didn't get to, which is, can the state justify that? Is that, I'm just asking whether you agree with that general legal,
well, I can't disagree with that. I agree that there are circumstances under which contracts can be impaired, but that doesn't address that doesn't apply necessarily to every contract. There are certain contracts which legal principles would suggest should not be analyzed under that framework. These pensions are one of them. The Supreme Court has said again and again, most recently, I believe,
that's okay, you don't have to, just.
the Supreme Court has said that when rights are fixed at the time of retirement, they shouldn't be changed. So, and I'm pointing out the case where the mayor had a disability pension. If rights are fixed at the time of retirement, then that is a class of contract where an impairment really should be, is effectively, I think, excluded from the more general analysis. Even in the earliest cases, they were estoppel cases, the Supreme Court talked about it, making adjustments to pensioners and payments. And said for these individuals, the race has already been run. So, if we accept the notion that there are contracts that can be impaired, I would suggest that there are contracts that can't be impaired. And the jurisprudence of this state, distinct from any other state, and that's why I don't think that out-of-state precedent has application, can be resolved by reference to those cases in which our courts have said the rights are fixed, there's been reliance, and in my view, there's nothing that my clients could have done to change their position in reliance on what the state has done, because they retired with an understanding of what they were going to get. So I would say yes, there are contracts that can be impaired. I would also suggest that there exists a class of contracts that can't be impaired, and that this is one that the pension with the COLA falls within that class.
Could you answer my question? Anything further?
Unless I think that if the court is assuming for purposes of argument the existence of the contract in the COLA within the non-forfeitable benefits program rights, then I would have nothing more to add other than to emphasize that the analysis can also be done under what a fundamental fairness, which seemed to be the way the Supreme Court was going in the last case. I think we get to the same place. If it doesn't have to be a remand, and the pensions are within that class of contracts. It can't and shouldn't
Thank you.